Good morning. Good morning. Happy or afternoon now. Happy Thursday to everyone. Thank you for joining us. If you were able to hop in early, you know that we had a little Q&A to see where you are, what you know, what your level of familiarity is with the subject, because knowledge is power. And what we talk about today and what's important today, a lot of it is just making sure you understand what the defaults are. So you have the choice. You can follow the defaults because they're already set up by the state and by statutory law. But you can pick your own path, and that can be very empowering, and it certainly can be very beneficial to your family if you choose to do so. But today we're talking about dying without a will. So you're opting to go with the defaults because, like most things in life, failure to make a decision doesn't mean a decision isn't made. It just means you're not in charge of the decision. And lots of us like control. We like to be in control of our finances. We like to be in control of what happens to our family. And so losing that control can be pretty scary. And we want to make sure if you do so, you do it willingly and you understand exactly what happens if you decide to not go forward and not put a will or a trust in place. So if you missed it, my name is Eleanor Curry. I am the managing member of the Curry Law Firm, and I have been doing a variety of things in law and real estate for the past 20 plus years. But in seeing and helping people start businesses, manage their businesses, grow their businesses, we saw a very particular need for learning more and getting more information about estate planning and how things can be set up. So today we sorry, about me, of course. I am a graduate. I have it from Florida A&M University, the Florida A&M University, and South Texas College of Law. I have an MBA and a JD, so I know a lot about business and setup. I am a serial entrepreneur, but more than that, I am a mother. I am a daughter. My mother recently passed, so this topic is certainly one I understand intimately. And I'm passionate. I'm very passionate about helping people grow their business, helping them understand the legacy. You may say, I don't have a lot, or what does it matter? I'll be dead. I hear those things all the time, but it can matter, and it can matter a lot. And small things and small efforts can have really, really magnified effect if you do things consistently over the years. So you may use insurance policies to build a nest egg for your family. You may use the equity in your home, but all sorts of ways in just your normal living, you may be building a legacy that's worth protecting. So, in today's seminar, what we want to talk about, most importantly, what happens in intestacy. And that is what the court calls when you die without a will. So, if you die intestate, that means you die with a will. But if you die in intestacy, you don't have a will, and the court will help you figure things out without a will. We're going to talk about some options outside of a will or a trust if you die without a will, including a small estate affidavit. And then we'll share some details on the alternative, putting a will in place, putting a trust in place, avoiding probate, which is also an option if you know how to properly use it. And of course, if you like what we're saying, you want to work with us, we'll give you some details on how to do so. So this is going to be the bulk of what I talk about today, just because it is very important. Intestacy law. What happens if you die without a will intestate? So what happens is the state laws pick up. And the state laws, especially in the state of Texas, because that's the state we're talking about, say everything goes to your heirs. Now, who are your heirs? First and foremost, your heirs are going to be your spouse and your children. However, if you don't have a spouse, if you don't have children, instead of going down, your spouse is vertical. You choose them, right? Your spouse. It will go down to your children. So if you have children, or those can be children that you have born, or children that have been legally adopted. If you don't have any of those, even though maybe you had a stepchild their whole life and you always care for them, if you haven't taken the step to legally adopt them, they are not considered your heir, and it will then go up to your parents. If your parents have predeceased you, it's going to go to who? Their children. So those will be your siblings. And it will continue to expand out like that, going up and then spreading out. So if it is anybody in your family that may be a distant cousin, and if you're ever wondering how people get called out from the state to collect inheritances from distant cousins, this is how it happens. You don't have kids and your parents have predeceased you. It's going to start a wider net, cast a wider net for who can be considered heirs. So lots of people, especially single people who may not have kids, say, I don't want my money to go to people I've never met or distant cousins or a particular family member who I don't get along with. Not only will they receive the benefit of your estate, meaning any assets, they may also be called in to make decisions for you in case of you being incapacitated. So you may be in the hospital and you may have the best of friends and a long-term boyfriend. Those people are not considered legally to be responsible for you. So just be aware that even though you may have the best of friends and the closest connections, the law looks at heirs and responsible parties a different way. So if you want to set away that's different than the default of the laws, then you have to put that plan in place. If not, it becomes very difficult and it requires legal action for someone to overcome that and say they should be the responsible party. The downside of that is you lose all of your power. You're starting to go through a court process that's going to follow its own laws. It's going to follow its own court procedure, and you don't have much of a say on not only who gets your assets, but who's in charge of distributing your estate and who's in charge of caring for you in case of your own capacitation. So the laws and understanding the default, which is still a law, which still is applicable to you, is important. If you want to specifically disinherit a child, maybe a child you don't agree with, or not have things go to your parents or a sibling, you have to put a plan in place yourself. If not, it goes to your spouse, it goes to your children, it goes to your parents, and then it goes to their children and expands from there. So that is the default. There is a plan in place. Even if you don't choose that plan, even if you don't like that plan, the plan is there and the state will go with it. And so if that does happen and you have assets someone wants to transfer from at your death, it goes to your estate. So it doesn't go to anyone automatically ever. The law rarely does anything automatically, right? So nothing happens automatically, but the court will move things to your estate, and then your estate can, through a variety of ways, release things to people you choose or that are the default, right? We're not talking about choice anymore. We're talking about the default. So we'll talk about a couple of options, but the most standard option is going through the probate process. So if you die without a will, people will have to go through the probate and present to the court that you do not have a will and that you should then follow the process of determining the heirs, which again, spouse, which you need a marriage certificate to prove, and making sure that you're not divorced. You do have to prove up if you're a common law spouse, meaning you have held yourself out to the public to be a spouse. Maybe you cohabitated, but you never went to the courthouse to finalize things and be recognized under the state as man and wife, or wife and wife, or man and man. And so you will have to still go through a process. If you present a will to the probate courts, or you present to the probate courts without a will, they are still going to say, we need to vet out and make sure these are indeed the children and these are all of the children. So there will be the court's own research process to prove heirship. They are going to appoint an attorney ad litem, which is a third party neutral person who's going to vet, hey, these are the kids, we have these birth certificates, but I'm going to put some feelers out to see if there are any kids who haven't been included, to see if all the kids who state that they are children have been legally recognized. Is your name on the birth certificate? If not, is there genetic testing that can prove it up? And they will also extend it out just to get a feel on if there are any heirs that have not been presented and have not been specifically mentioned. So if you're a parent, and this happens, people get surprised all the time, had a separate family or a different account, as heirs, everyone has equal access to their rights to an estate. There is no you get more because you were the kid they cared for, and you get more because you took care of your dad. There is none of that. That court does not care. If you can legally prove a parental relationship, they will recognize you as heirs. If you were someone's long-term partner, but you never proved things or finished the process to get married, you need to prove up even your position as a common law wife or common law husband or common law spouse. So just make sure you clearly understand that. As far as accessing other assets that the person have, many people do put a beneficiary on your bank account or different accounts or even insurance policies. But just note that not all banks will automatically approve that. They won't all just allow you to proceed in picking up all of someone's assets. A lot of times they will want some sort of heirship affidavit to prove you have authority. They may want a finalized small estate affidavit, but they want to make sure someone's not going to come back and sue them and say, hey, you released all of the person's assets to the wrong person. So often when they catch wind through an obituary or through their own searches of public data that someone's deceased, they will freeze an account. And once frozen, you have to follow the bank's procedure to release those funds, even if you have been appointed as a beneficiary. So because you don't have instantaneous access to their accounts, even if you are a child, even if you're a spouse, that can cause big and major delays in mortgage payments and property transfers. And it can, again, require court action to fix that. So it may not be a simple fix. It can take time. It can take money. And when someone dies, and I found this out the hard way when my mom died, there are a lot of expenses that have to be paid for immediately. From my own experience, I'll tell you, your death certificate doesn't even come out for many days after the death. And often you have already had or are close to having their memorial services even before you get a death certificate. And if nothing else, you definitely need a death certificate, even if you are the beneficiary to some of these accounts. So you have the probate process, and then for individual assets, you may be listed or you may direct the bank or an insurance company or even for your 401k and things like that to pay out to a specific person, but they will need your death certificate in order to access those things. So nothing is instantaneous. I don't care if you're the heir, unless you have a account with someone. You guys are both joint owners. That is the only way to get around some of these requirements. So one option, you have the going through probate without a will. So it's still a legal procedure. You have to file into the court. It is a petition, so you're going through the probate courts. It can take time. They're going to take time to publish and try to find heirs by appointing that ad litem. They're going to still do public notice that that person is deceased and allow an opportunity for anyone who is a debt, may claim a debt, to come present and say, hey, they owe us money. So you're following the same probate procedure. However, you have an additional step to determine heirs. And once heirs are determined, those heirs can petition to be the administrator or to manage things, or the court can self-appoint someone. So that is option one. Option two is what we call a small estate affidavit. And this works, but only for estates that have less than $75,000 worth of value. So you're going to present to a court some paperwork that itemizes all of the estate's assets of the estate. Hey, he didn't own his own home, but here's a car that he owned that was paid off. Here's bank accounts. And if that total of all of the assets is under $75,000, you can properly apply for a small estate affidavit. Now, the challenge with that is if you own a home, chances are it costs more than $75,000 from the way that it is being evaluated and valued by the court. So often this can be difficult or impossible to prove if someone did own real property, and the court is going to vet it, right? So if you say, hey, I'm just going to say he bought it for $50,000 and I want to put that down as a value, and that was 30 years ago, the court can probably pretty easily see that that value is not the current value of the estate, and that this is not the proper venue for you to get things finalized on the estate. So it's still a legal process. The court is going to review what you said, and the court is going to make sure you have verified the heirs and presented all parties because they don't want siblings left out, sometimes intentionally, sometimes unintentionally, but they want to make sure all of the parties that are now going to be transferred the value of the estate are included in this proceeding. So the beautiful part about this is that you do avoid probate, and it allows for smooth and pretty quick distribution of assets. Once you present your documents, it's been vetted by the court, you have a hearing, most of the time they will grant you access. So this is a much quicker option than probate. However, it does not apply to everyone, and you have to be careful because you don't want to take the steps to follow this procedure and then find out that that estate, because of the value, does not qualify. I did want to mention, it's not included, that there is something else just for real property called an heirship affidavit. Again, you're going to list out the heirs as you know them. You're going to have two disinterested witnesses attest that these are the heirs that they are aware of. No other heirs are known. They're going to state their relationship with the decedent, which is who we call the dead person. So they're going to check their relationship and verify their relationship with the decedent, and that can be an alternative way to transfer only real property. Okay, so no planning. Boom, you're here. You didn't get to putting a will in place. You didn't get to putting a trust in place. And now your loved ones are left scrambling, trying to figure out what to do. So they will have limited access to funds. Again, you'll need your death certificate for anything. And your death certificate may appoint one person, but you may have 5 kids. And you really want to make sure that the distribution is equal, that it is a reflection of your wishes, and that there is no interruption in day-to-day activities. That could be paying the mortgage. That could just even be something as simple as having access to your internet or to your email address to verify if Reliant sends you a message or if your power company sends you a message, right? So it can be something as simple as that. And now you've left the burden of figuring out what goes where, what are your responsibilities, what bills need to be paid and don't need to be paid, to people who may not have been involved in the day-to-day activities of your financial affairs. So there's a lot of confusion that comes from that. And there's a lot of trying to reorganize, try to gather assets, trying to pay for this and that can cause havoc on your plans and even your accounts, because your mortgage gets behind, property taxes aren't paid, you may lose some exemptions. All of these things can compile to a big problem for anyone who's left and who still earnestly wants to honor your wishes and do things as they believe you will want things done. So the saddest part and the most exhausting part for me is that it leaves people who previously may have been skipping down the road together in conflict and with uncertainty. They don't know what you really wanted. They don't know if you wanted to leave something for Lisa or John. They don't know where great granny's ring or clock goes. And so that causes conflict. And while this may seem minor, hey, I don't have much, I've seen people spend $6,000 on appraisals for $4,000 worth of jewelry, right? So they're paying more than it's even worth because, one, often that will be the court's request. They don't know what your value is. They don't know if your mom's wedding ring is real or not. And so they just work in numbers. They don't work in sentimental value. They don't work in anything other than what can easily be determined by a neutral third party. They're not intimately involved. They don't know that Big Mama's house was supposed to stay in the family. They don't know that, John took care of Mama for 20 years and lived with her. They don't know any of these things, and it's not their concern. So if it is your concern as someone who, like me, was caring for an aging parent, or if it's your concern for making sure you're providing for your own family, just know that the court is going to take a very pragmatic, a very distant approach to how to assess all these things. If you guys can't come up with a plan yourselves on how things are distributed, they're going to look at everything from a monetary value, which is either gather everything and sell it and distribute the money, or you guys agree. Otherwise, they don't know. And the process of the court system is they don't like these type of intimate family problems to clog out the court system. Great thing, though. You get to decide. You can take charge early. So we know if you die intestate, you have to determine your heirs. The court will decide based on the heirs available where things goes. But you can take control of things. You don't have to just let your personal choices and wishes falls to the wayside. You can decide who gets Granny's clock and who gets your favorite watch and who gets your car. You can decide if friends instead of just family are going to be included in who you're leaving things to. You can decide what charities that have been near to dear in your heart in your lifetime get the benefit of some endowment from your estate. All of those can be your choices. You have in your lifetime the full right to make those choices, but you have to start making the decision. So let's talk about how. Um, an estate plan can put over together a variety of things. And I tell people all the time, if you can dream it, I could probably put it together in either a will or a trust. So a trust or a will is going to outline a plan that you have for the distribution of your assets, but also who's in charge of this distribution. It could be a third party. You may work with Merrill Lynch as a bank, and you decide that they are going to be the person who manages your assets, who controls things, and who makes distributions to the beneficiaries that you have outlined. But you want to also make sure that you have put plans in place for you. And some of the things that will come along in a estate plan, such as a medical power of attorney, a durable power of attorney, medical directives, are things just for the management of you in case of your incapacitation. Now, I know that is equally as unattractive to look at as perhaps death, but it certainly is important. If you have Alzheimer's and someone needs to decide if you're going to stay at home or go to a skilled nursing facility, if they're going to decide what decisions you want made, if they are making decisions at the hospital, if they're going to decide how to manage your finances for your own care. Even without a will or a trust, you can begin to put some things in place on these particular things. So if you say, I don't have the money for a will, I don't have a desire to make a trust, please, please, please put together some things just on how to treat you in your own incapacitation. The reality of life is we never know. Certainly, we always want good things to happen, but we know for certain that bad things happen as well. And you have the ability now, while you have capacity, you're in your right mind, you can make decisions for yourself to decide who gets to make those decisions. You may have someone in your life that you love, 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 and you trust. However, they may not be good at making medical decisions. They may not know your head from your toe when it comes to medical decisions. Maybe you want to put someone else in charge for those decisions. A durable power of attorney is going to talk about your finances and property. Again, someone you love and trust, but could not manage their way out of $50. If you have $100,000, they may not be the best person to put in charge, even though the love is real, the connection is real, the trust is real. They just don't have the capacity. Your need does not instantly make someone a money manager. It doesn't instantly make someone give someone the education to understand your estate. It doesn't tell people where your passwords are or where your important documents are. So just because you need them to doesn't mean they can or they can't easily in the time frame that would be helpful to you. So put some things in place, if nothing else, just for you. Even if you say, well, I'm dead, what does it matter? Well, your will and your trust will come with some of these things, but if you don't put a will in place, if you don't put a trust in place, make sure that you care for yourself in case you're incapacitated and someone has to make decisions, because you don't want to wake up after maybe you're put in a medically induced coma and now you wake up and you say, where am I and where is all of my money? And yes, I definitely could share horror stories of people waking up and their sister, brother, loved one took all of their money, put them in a nursing home and ran away. Right? That is a horrible situation and certainly a worst case scenario, but it does happen and I don't want it to happen to any of you. So a will is just a written instrument that gives instructions. You're going to provide beneficiaries, all of, and who you want to include, because not everyone who is an heir may be someone you want to include as a beneficiary of your estate. Again, this is a place to note giving someone specific items, perhaps a car or perhaps some other item of personal property, and also making sure that you've put in charge someone that you think can be responsible for these distributions. So the person you put in charge may not be someone who's actually a beneficiary of your will. It may just be someone you trust, and it may be a third party completely separate, because that way they're not in the family drama. They don't have a sentimental decision to make. They're just making and following your instructions. So they're making decisions that follow those instructions. Again, you still have to go through the probate process, but it's not an intestate process, meaning the default laws of the state won't apply. They're going to follow your wishes as long as they can. For instance, if you say, my son is going to be the administrator of my estate, and your son is a felon or in prison, he can't actually take that role. So there are going to be some defaults and ways they step in if things can't be fulfilled as written in your will, but it is an amazing place to start, and it certainly streamlines the process and makes things easier for your beneficiaries. And then a trust is a little more formal of a process that begins now. It doesn't just pop up like a will does at the time of your death. This is something that you begin to work, funds, move assets to right now in your life, similar to if it was a company or LLC. So it's a legal arrangement that holds and distributes assets first in your lifetime, holding them, and then in your incapacitation, distributing them for your benefit, and then at the time of your death, distributing them per your instructions to your beneficiaries. Again, you get to avoid, this is the only one, not again, you get to avoid probate. Ding, ding, ding. A big win for people because probate can frequently cost $5,000, $10,000, $15,000, and it can take time. It certainly will always take time. Fastest, maybe 6 months, but longest several years. So you'll get to avoid that whole process. And at the time of your death, your trustee or your subsequent trustee can begin to take action immediately, doing things that behoove you and follow your instructions. So it's like a VIP distribution. You don't have to wait in line. You don't have to collect past go. You can just begin to do things instantly. So a great way to put a plan in place, and certainly a great way to put a plan in place that is more long-term. If you're thinking generational, if you're thinking about legacy, a trust is a great place to start because you can leave instructions that span generations. You can leave instructions that distribute assets every decade. You can leave instructions that are specific to things that are important to you in your lifetime. That could be going to college, starting a business, buying a new house. It will work specifically per your instructions, which means you have the opportunity to put things that are legacy building to you in it and have control over how that distribution works. So the ball is in your court. You fail to make a decision, decisions will still be made, or you can make decisions that are reflective of you and what you want done. If you die without a will, your voice, your control goes away. The state's process controls if you die without a will. So the estate planning is really just that, a plan that protects your family, your assets, and you in case of your incapacitation. So how can we help? Every estate plan is different. Everyone who comes to me has a different plan in mind. They have a different beneficiary. Different things are important to you. And this part is a legacy. Sharing with your family, hey, I've built money through investing in the stock exchange. So the money I'm going to give you is going to be you have to access by taking a class in stock trading, right? That can be a part of your will or your trust. And that's an important way to leave that legacy behind. That's educational and information about you, about what you see is important, about how you got the assets that you were able to achieve in your lifetime, and how you think they can continue to grow. We do representation and probate. So if you die with or without a will, helping clients through that process, even avoiding probate through some of the alternatives like a small estate affidavit. And then if it's necessary to have guardianship of either a parent who has become incapacitated or a child or special needs person in your family, we certainly assist with that along the way. Again, the focus is helping you with the personalized needs that you have in your life. Everyone's situation will be different. And so there's an approach with our law firm for those varying differences for everyone. So if you do want to get started, if you are looking for representation or you just have questions on what to do, you can always reach out to us. Our number is 713-574-2070, or check us out at www.planwithtrust.com or www.theclfirm.com. We're happy to help, we're happy to listen, and we're happy to empower you to make decisions that are good for you and your family. Thanks so much for attending, and we'll check you out next time.